dead and well. I don't know. I don't know how that works out, but
Yeah.
hi, Evan. We only talked on the phone, but I appreciate it so much. You taking the time out of your schedule to come and do this. So, we are going to wait just a couple of minutes to get started, and let some people trickle in. But yeah.
See if I can find a way to get myself better lit here.
All right. So we'll give it till 8:35, and then we'll go ahead and get started. I'll do a brief introduction from what I know. So,
All right.
also, Chung, I'm going to read your message. I promise.
It's okay. I know I made it long on purpose.
Oh, okay. As long as it's on purpose. Okay. But yeah, I'll read it.
You can
After
read it right now.
take my time. Okay. As long as you mean that. I
Yeah.
will.
Maybe.
Okay. Ooh. Extremely gutted. I like that. These are good words. No, I'm just kidding.
That's just walls at
Sounds like a hot mess. Okay. What? All right. Good job. Good job. Good job. Good job. How'd the conversation go?
It was good. It was just flowing. Like she was just letting everything out on me. I didn't really have to like pull teeth on it. So, and I was able to ask any questions I wanted, and she would just respond without being like apprehensive or anything.
Nice. Okay. We'll listen to that one. Yeah, I don't know. At some point.
Good point. Tomorrow.
Tomorrow? Yeah, we can do tomorrow. Yeah. Oh, right. Okay. All right. I might lie. All right. We're not going to do 8:35. We're going to do 8:34. We got 4 more seconds. I lied. Boom. All right. 8:34. All right, guys. Welcome tonight. I am very excited. We have a guest, Evan. He is a bankruptcy attorney that works out of the Temple area or close to it. He works in that area. So, interesting way I connected with him was through an agent that he works with locally, and he was highly recommended, and the agent told me Evan's the best, and he's been working with Evan for a while. So thank you again, Evan, for coming out, and he's doing this completely off of one call. So Evan, if you want to go ahead and introduce yourself, you can do that and just tell us who you are, how you got started, and roll right into it.
Happy to be here, and thank you very much. Yeah, so I'm a consumer bankruptcy attorney operating out of Waco, Temple, Killeen area and the surrounding counties. I've been doing bankruptcy now for about 14 years, and basically started almost directly out of law school, which I went to rather late in life. Before that, I was a mathematician and computer programmer. So that's a little nugget about me.
Okay.
Would you like me to just launch into talking about bankruptcy?
yeah, there's going to be tons of questions. So whatever you got set up, roll into it. And then when you're ready for questions, we'll just, kind of open up the floor.
Sounds good. Okay, so bankruptcy is a creation of federal law. It is entirely defined by Title 11 of the United States Code and operates completely in federal courts. I'm not going to give any kind of history of bankruptcy, but modern bankruptcy is essentially meant as an attempt to sort of balance the interests of creditors and debtors. Individuals, companies, municipalities, foreign entities can all be debtors in bankruptcy. Railroads, there's even a special provision for them. Most people are concerned with the provisions for individuals and companies. And the different kinds of bankruptcy that they can engage in are described by the different chapters of Title 11. So you may have heard of companies filing under Chapter 11 or people filing Chapter 7 or 13. And each of those chapters describes sort of a different flavor of bankruptcy that is aimed at accomplishing different goals with different powers. Chapter 11 is mainly about business reorganization. Individuals can file it, but they rarely do unless they have a lot of debt and a lot of assets, and they need something really complicated, because Chapter 11, while very powerful, is also the most difficult kind of bankruptcy to do. I don't practice it myself. I'm not qualified to do Chapter 11. Chapter 7 is the kind of bankruptcy that both individuals and corporations will typically file to get a fresh start, or in the case of a corporation, go into liquidation and just wrap itself up. Chapter 13 is bankruptcy reorganization for individuals. It's for mostly ordinary people who need to save a house or save a car, or want to deal with their debts and would love to have a Chapter 7, but have too much income or have property that wouldn't be protected. What ties all of these together is that when a debtor first files a bankruptcy case, they immediately get an automatic court order telling all of their creditors that they need to back off. It's called the automatic stay. And what it means is that without even having to file any other papers in front of a judge, just opening a bankruptcy case means that foreclosures are stopped, repossessions are forbidden, all collection activity has to stop. And that is true of 7s, 11s, and 13s. I'll briefly mention there's also Chapter 12, which is almost the same as 13, except it's meant for family farmers and fishermen, but otherwise operates the same. And at the end of the typical bankruptcy case, you get what's called a discharge of your debts, which is to say, you get a permanent order from the court telling your creditors that they are not allowed to ever try to collect certain debts from you again, whether they got paid nothing, part, or all of what they were initially owed at the start of the bankruptcy case. The thing that distinguishes Chapter 7 from Chapter 13 is that in Chapter 7, you're typically just trying to get rid of debt, get a fresh start is the way people typically put it. This is the kind of bankruptcy that people are looking for when they just have lots of credit card and medical debt, and they just can't afford it anymore. Chapter 13, I used the jargon reorganization because in Chapter 13, it's almost a court-ordered consolidation of debts. It just pulls all the debts together and says, we're going to pay certain debts in full. Like if somebody wants to save their car, the bankruptcy will pay their entire debt on the car. If they're trying to save a house, typically the Chapter 13 bankruptcy will just give them a period of time during which they can catch up the mortgage. It won't pay off the mortgage during the bankruptcy, but it'll at least let them put it back where it needed to be, so that when the bankruptcy is over, they can just get back to paying their mortgage normally. Chapter 7, so when someone comes to me and says, I have debts that I can't deal with and I need help, the first things that I look at are are they just trying to get relief from some of their debts, or are they trying to protect something? And that's the major thing, as I've said, that usually distinguishes 7 from 13. And if somebody just wants to try and get a fresh start, I start looking at, well, can they do a Chapter 7? Because if they can, that's the more straightforward and easier way to help them. And because in Chapter 7, as long as you meet certain tests having to do with your income, and as long as you don't have any property that would be unprotected in the bankruptcy, and that unless you're willing to let it go, that's the way we want to go with it. As far as income goes, because I mentioned there are income limits, in order to be able to file a Chapter 7, most people need to have an income that at least in the 6 months leading up to the bankruptcy and around the time of the bankruptcy is at or below the median level of incomes for a household of their size. And to give you an example, the median income for a household of one right now is around $60,000 a year. For two people, it's around $75,000, and it goes up to over $100,000 for 5 or 6 people. And so if somebody comes to me, the first thing I do is check to see where their income is at. If it's below that level, great. Don't have to worry about that. They can do a Chapter 7 from that point of view. If it's above that, there may be an exception to that. For example, if someone has mainly business debts, they can get around the income limits. But otherwise, we look at saying, well, maybe you might have to file a Chapter 13 and pay back some of your debts. The next thing that I look at is what property do they have? Because one of the things that you do in each kind of bankruptcy is you list everything you own, and that includes real estate, vehicles, household goods, stocks, bonds, cash, retirement accounts, copyrights, stocks, bonds, literally anything and everything you might own, up to and including things like, well, I had a slip and fall in a store and maybe I could sue somebody over that, but I haven't even talked to a lawyer about it yet. That is, that potential ability to sue someone is an asset that you would want to list in your bankruptcy, or you would lose the right to pursue it. After we've listed all of the things that you own, we try to assign a value to them, which is typically the market value of the asset. And we line up against that the value of any debts they may have in it. So if you own your home and your home is worth $300,000 and you have a $200,000 mortgage on it, then we line all that up and say, well, you've got $100,000 of equity in it once you subtract the debts from the value of the home. And if you want to keep the home, we need to be able to protect that equity. There are rules in bankruptcy that are used to protect property or the equity in the property. That is something that varies from state to state. I practice almost exclusively in Texas, but there are circumstances where if somebody has just recently moved from another state, they still have to use the rules of that other state. So bankruptcy practitioners do have to know about how those differences line up, even if they only operate in a single area. But most of the time, if somebody has lived here in Texas for a while, they have a choice between using rules that are set up in Texas law to protect property, generally against creditors. And this is non-bankruptcy specific. This is just ordinary rules. For example, the Texas Constitution says that people's homesteads are protected against their creditors unless those creditors are specifically a mortgage or someone who is directly involved in, say, making repairs to that property. And so bankruptcy here can either use those Texas specific rules to protect your assets, or it can use a set of bankruptcy specific rules that are laid out in those Title 11 laws. Here in Texas, because our homestead protection is so generous, generally speaking, I'm going to be using those if somebody has more than about $40,000 of equity in their home. It's also really good for protecting free and clear vehicles. Really about the only thing that Texas rules are not great at is just protecting cash in the bank or protecting other properties that are not your homestead. So having said all of that, like I say, we list the property, we value it, subtract the debts from the value to find the equity, protect what we can. And then at that point, assuming that the person wants to go ahead with the Chapter 7, any property that they own that is not protected, what's called non-exempt property, theoretically at least, can be taken by the bankruptcy trustee, the person that the court hires to administer all of this. If there is a significant amount of that property, they will collect it up, they will liquidate it, hold auctions and whatnot to turn it into cash, and then they'll send out notices to all the creditors saying, there's money here, please submit your claims, tell us how much you're owed, and then he divides the money up amongst them. Most of the time, I'm not filing Chapter 7s for people who do have unprotected assets. Most of the people who come to me may or may not have any real estate at all, but if they do, it's their homestead. Usually they just have 1 or 2 vehicles and those are protected. They have their ordinary personal property. They may have a retirement account, which is also fully protected under the law. And as long as we can arrange for them to sort of spend down their money, which is usually not a problem, to under about $1,000 by the time we file the bankruptcy case, they get to keep everything. And they just get that fresh start. Chapter 13 works in some similar ways. As I said, it is more oriented towards holding on to things that you're in danger of losing. And that's because whereas in a Chapter 7, you file the case, they determine whether you have any property that's not protected, and if not, it just ends and you get your discharge. In Chapter 13, you make a payment plan that lasts 3 to 5 years. And you put all of your debts into the bankruptcy, and you then say, okay, I've got a mortgage over here. I'm current on the mortgage. I'm just going to keep paying that normally. I've got this vehicle and I was 2 or 3 payments behind on the vehicle and they were about to pick it up. That has stopped because I have filed this bankruptcy. But in my plan of reorganization, I'm going to say that car creditor is going to get paid the full amount that they are owed in monthly payments over the next 3 to 5 years. And I'm going to pay them a fair interest rate, although not necessarily the amount that they would have gotten under the original loan contract. And they're just going to have to sit back and wait to see that money come in. And the person who filed the bankruptcy will then start making monthly payments to that bankruptcy trustee. And each month they will divide that money up based on the plan of reorganization that's been approved by the court. And so usually in these situations where we're saving a house or saving a car, for a long time, the payments mainly go toward that and toward paying my attorney fees. And then towards the end of the plan, once the attorney fees have been paid and once, say, the vehicle has been paid off or the amount that they were behind on the mortgage has been caught up, then unsecured creditors, people like credit cards, medical bills, folks like that, will get some of their money. If the person filing the bankruptcy has good income and they say just had a temporary shock, like they had some kind of medical emergency, or they had, a 6-month loss of a job, but then they went back and they were able to make good money again, but they were behind on things and were about to lose them if that wasn't stopped, they might end up paying 100% of their debts. They might just pay everybody everything that they're owed and come out the other end having not really gotten rid of any debt except by just paying it off in a slightly different fashion than they would have originally. On the other hand, we have people who go in and they have very little income and they sometimes have a hard time of it and they pay off their car. And then at the end, they have paid 1 or 2 cents on the dollar on the other debts. And then the discharge at the end takes care of the rest and they're done. I think that's kind of the highlights. Certainly that's the end of my standard spiel. So I guess that's only been about 15 minutes. But if we want to get to questions, certainly if you want to highlight areas that I may have not not thought to talk about.
No, looks like there's a lot of questions. That was-
Yeah, I was trying to beat Gordon to the punch. I didn't think he was gonna do it that fast.
That's
So
fine.
I'm already down. But yeah, so we'll just go in order. Gordon, myself, Noah, and then we'll keep going.
Cool. Hey, Evan, thanks for having this. Totally appreciate it. Great information. Yeah, a couple questions. So number one, how could this be utilized to benefit a homeowner? Because this is all very homeowner specific as far as like, I think a lot of us are concerned with real estate. Dealing with foreclosures. And I know from what I understand, a foreclosure can be stopped with a bankruptcy, but is that only to buy time, or is that like what sort of benefits are there for the homeowner with the bankruptcy?
So usually there's two scenarios that I encounter. Both of them start with someone coming to me and saying, "Oh my God, I have a foreclosure coming up in a month or 2 weeks, or occasionally a day or two," and filing a bankruptcy case for them. As I said, the automatic court order that goes into effect the moment the bankruptcy case is filed means that the foreclosure is not going to take place now. That part is temporary, because if they file that bankruptcy case and then do nothing more, it's going to end, the protection is going to be lifted, and the mortgage company go right back to what it was doing. So at that point, usually we're filing a Chapter 13, like I mentioned, the reorganization, because it does have built into it that ability to say, well, I'm going to pay the bankruptcy trustee $1,200 a month out of my ongoing income, and he is going to use that to make my $900 mortgage payment each month as it comes due. And I was behind on my mortgage by $5,000. And over the course of the 5 years of my plan, the $1,200 I pay to the trustee will cover each new $900 payment as it comes due, and then he'll send them an extra $250 a month until that $5,000 has been caught up, and the rest of it will go to paying my attorney, a little bit of paying the other debts, and then when it's all over and done with, I'm caught up on my mortgage because all the payments that came due during the bankruptcy have been paid. All of the payments I was behind at the start have been paid. Everything's back on track. I just go back to making my normal payments when it ends. And so that saves the house for them. The other scenario is we file the bankruptcy and then determine that the person, and sometimes they know this going in, just can't afford to do that. Because the one thing that the bankruptcy can't solve is just not enough income. If their payments are $900 a month and they're $5,000 behind and they're on fixed income, and after they pay their food and their light bills and everything, they can only afford to pay $500 a month. The math just doesn't work, and there's nothing we can do about that. What we'll sometimes do in that case is we'll say, well, you do have $50,000 of equity in this house, and it would be a shame if you just lost that. So let's tell the mortgage company, hey, mortgage company, we're going to try and sell this house and get you paid. And we're going to say that if we don't get that done within 6 months, then the bankruptcy protection will end and you can go back to your foreclosure. But at least we now have a 6-month window to try and find a buyer and get you paid off.
Got it. Well, so how does bankruptcy specifically affect credit? Because it must be pretty bad, right? It's like foreclosure, you're kind of screwed for 10 years, so to speak.
Not as bad as people think. So once you file a bankruptcy case, whether you follow through with it or not, of course, it goes on your credit, and it's just a little line item there saying that you filed a 7 or you filed a 13 and whether or not you got a discharge in it. And that is a negative on your credit. I couldn't tell you in specific terms of score. I've never gotten into any of that. But I do know that someone who, for example, comes to me and has been late or not making payments on all their credit cards for 6 months because they just couldn't, and their score has gotten down to 400 or 500. If I file a Chapter 7 bankruptcy for them and get them a fresh start, typically their score goes up 50 to 100 points directly after the bankruptcy is done and they've gotten their discharge. And it just goes up from there with normal credit building and can be pretty much back in the normal range within a year or two, even though the bankruptcy is still on the credit report for a full 10 years. Once there's been a little bit of credit building, it's not a problem. And just to put it in very concrete terms, people get car loans not only directly after they filed a bankruptcy, but they can actually do it during bankruptcy. I have somebody who I refer people to who is a specialist in financing replacement vehicles during a bankruptcy. And they don't look at people's credit score. They just are like, does this person have income? Can they make a payment?
Right. And so you mentioned something about agreeing upon an interest rate that might not be what was negotiated originally in the terms. How does the court circumvent the contract that's in place with the current interest, let's say a car loan interest or credit card interest? How do they circumvent that?
Okay, so I mentioned how in Chapter 13 you essentially have a payment plan and you have you have laid out what you want to accomplish. There is a specific plan of reorganization that the debtor actually files at the start of a Chapter 13 case. And there are some limits on what it is allowed to do, but within those limits, it can basically say, I want to modify the terms of these loans that I have entered into, specifically just as a blanket matter when it comes to unsecured debts. It just says, none of them is going to accumulate any interest. None of them is going to accumulate any fees. They're going to be frozen at the amount that they were at the start of the case, and they will get paid some percentage of what they are owed, and then they will be done. More to your point, when it comes to, say, a vehicle loan, regardless of how many years that loan may have had left in it, it is routine, essentially, to just say, well, we're going to pay them $200 a month, and we're going to give them 9.5% interest, regardless of what the interest rate was on the original loan contract. And as long as the judge approves that plan, the terms of the plan essentially replace the terms of the loan contract as long as it is successfully carried out. So if somebody says, okay, I'm going into a Chapter 13 bankruptcy to save my car, I had a 22% interest rate, and I had 4 years to go, but I'm going to pay it out over 5 years, and then they're going to get 9.5% interest because that's sort of the going rate in bankruptcy right now. And they make all the payments. At the end of it, the car lender has to turn the title over, and they can't collect any further money. If the person gets halfway through and they stop making the payments to the trustee and the bankruptcy gets canceled, then they're back. Once the bankruptcy ends, they're back under the original loan contract rules. The lender still has to give them credit for however much money they got paid, but they can go back and recalculate everything from the start and say, yep, you always had 22% interest, and yeah, I got some money, but now you're $6,000 behind. What are you going to do about it?
Got it. Thank you.
Mortgages are excluded from a lot of those things. We can't change the interest rate on a mortgage. Mostly we are limited to just saying we were going to maintain the normal payments while catching up the amount that they were behind over time.
And that time is dependent on whatever you can negotiate and have the judge approve.
Mostly have a judge approve. There is rarely negotiation. Most of the time, and this is mostly just because of the experience of bankruptcy lawyers over time, the creditors typically are not coming to court and protesting the deal that they're being offered, because the deal that they're being offered is not unreasonable in the eyes of the court. We know what the judges will approve, and so we're not going in there and saying, oh yeah, we're we're going to pay off this car loan that only has $2,000 to go at $50 a month with 2% interest. If we were to try something like that, then the car lender would mostly come to court and say, Judge, this is not reasonable. The car is depreciating faster than that, and this is just too much. And the judge would probably agree. So most of the time, there's not a negotiation, but it's only because we're putting forward something that they understand that they will probably lose if they come to court and try and challenge it.
Got it. Thank you.
Okay. I have like 50 questions, but I'll try to make it as concise as possible. So I wanted to touch on something you said earlier with the bankruptcy dismissal. You said like after that, you might go to the lender and ask for like a 6-month window to try to sell the property if they have equity. Is that something that the lender normally offers up, or you have to, talk to them after that dismissal?
Well, so the 6-month window that I was talking about was not after dismissal. That was if I'm filing a Chapter 13 bankruptcy and I either knew going in or find out right after, because this is one of the people who came to me 2 days before foreclosure, and I didn't get all of their financials until a few days after I have filed their case. And I find out, oh, you can't afford this. Your only reasonable option is to hope for a miracle or try to sell. And so then what I do is I actually make the bankruptcy plan proposal be, hey, we're going to try to sell this property and satisfy the debt that way. Because that is something you're allowed to do. It is most usual to pay your creditors in a Chapter 13 bankruptcy out of your monthly income, but it is also allowed to be through sale of assets. So if somebody goes into a Chapter 13 and they have, say, a free and clear house investment property that they have been using as a rental, and they're willing to part with it, they could propose a bankruptcy plan that says, you know what, I'm not going to be making monthly payments out of my income. I'm just going to sell this property over here, and then I'm going to sink $100,000 into bankruptcy, and that's going to take care of everybody. So what I was talking about there is a much more specific version of that, which is just, on paper, this house is worth more than the mortgage on it. And so we're just going to ask to be given 6 months of the bankruptcy protection to try to sell it. And the reason that I specifically say 6 months is because if I tried to file a plan, as I was mentioning in the other context, if I tried to file a plan saying, oh yeah, I want to have up to 5 years to sell this house, don't worry, you'll get your money eventually, then the mortgage company would come to court and say, no, that's not, we can't accept that. And the judge would probably say, yeah, Mr. Simpson, you're asking for way too much. And so I tend to basically take the position that in most ordinary situations, if they're going to be able to sell their house, they're probably going to be able to do it within 6 to 8 months. And so I just say, okay, mortgage company, don't worry, you're going to have to wait this long and no longer.
Okay. All right. That makes more sense. So, another question. Is there a minimum amount of debt someone has to have before you'll consider like, hey, I'll file your bankruptcy?
I mean, the way you phrased it, yes. There's no, if you had asked me, is there a minimum amount of debt you have to be able to file bankruptcy? The answer would be no. Technically, you can file a bankruptcy not owing anybody any money. There just wouldn't be much point. But yeah, if someone comes to me, and this has happened, and says, oh, I have debts that I can't manage, and I say, oh, okay, well, tell me about it. And you say, well, I've got this $500 credit card, and then I've got this $200 payday loan. And no, that's it. And I say, oh, well, I'm going to charge you a standard of $2,500 to file your case. So if you have that money, you're probably best off just taking $750 of it and going and paying those 2 debts. And if you don't, I'm real sorry, but I can't help you except to give you a little advice, perhaps on whether they'll actually even be able to collect those debts from you.
Okay, that makes sense. Okay. So then what typically causes for a bankruptcy to be denied?
Let's see. So Chapter 7, about the only circumstance where I wouldn't typically, if somebody comes to me and they want to file a Chapter 7, and I think that there would be something that would cause it to fail, I'm not going to file it in the first place. So usually the only thing that could really go wrong in a Chapter 7 is it turns out that my client has been lying to me about what they owe or what they own or what they earn. And the court finds out about that. Thankfully, that has not happened to me. But generally speaking, once I file a Chapter 7, I can be 99% sure that it's just going to go on rails, and it's just going to be 3 months later and they'll get their discharge. Chapter 13 bankruptcy, because it is 3 to 5 years of payments, the thing that can most easily derail that is some new financial shock happens. They got into the bank, they got behind and had to file bankruptcy because they lost a job, but now they've got a new one, and we file the case and they go in it for a year and then they lose that job. And now they can't make the ongoing bankruptcy payments. And that's not automatic failure, because there is some flexibility. If somebody loses their job during bankruptcy and it takes them a month or two to get a new job and get the income rolling again, I can ask the court, and the court will often say, okay, we can take a payment or two and spread it out over the rest of the bankruptcy case. Generally speaking, if somebody's gotten behind on the payments, what happens is that the bankruptcy trustee is the one who says, hey, I handle the money and I haven't gotten a payment from this particular person in 2 months now. So I'm going to request that this case be dismissed. There are some circumstances under which he is allowed to just say, it's gone, it's over. But usually that's if somebody has filed multiple bankruptcies or has other special circumstances. More usually he'll say, okay, judge, please set a hearing. Let's talk about this. And then I will have the opportunity to go in and say, yeah, they have gotten behind, but here is our proposal for how we're going to get that fixed. They've gotten help from a family member, or they've gotten a new job, or what have you. And so here's what we're going to do. And we work things out and the bankruptcy continues. But that's the biggest thing that kills it is somebody loses a job, car gets totaled, they get hospitalized, things happen.
Okay. Because I'm thinking before it even gets approved, let's say it goes in front of a judge and the judge says no can do. Is that typically solely because of income to where they would never get that Chapter 13, or are there other factors?
Yeah, I mean, usually when we're talking about whether we can get a plan approved, it's going to be, are we asking for something that is generally reasonable? And that's where, like I talked about, that kind of comes down to the experience of the courts and the bankruptcy lawyers together, what has worked in the past. And we've sort of tested the boundaries of various things and found what works and what doesn't. There can be some of the non-financial things that can cause a lot of trouble are if the person is not cooperating either with their attorney or with the court, because a lot of the time at the very start of a bankruptcy, the trustee will say, okay, I need to see how this person's finances are going now that the bankruptcy has started. So please give me the bank statements that have come out since they filed the bankruptcy case and the pay stubs that they've gotten from their job. And they put down here on their budget that they tithe $400 a month to their church. So please have them get me some kind of document from the church testifying that that is in fact the case. And if we give all that to the trustee and he looks at it and says, okay, I see on these bank statements that they are spending the things that you indicated that they are spending for utilities and clothing and all that sort of jazz, then the trustee will typically give a report to the judge and say, Judge, I've examined all of this. It all seems reasonable to me. I don't have any problem with this. I recommend confirmation. And often in that case, the judge always makes his own independent judgment about all of this, but it weighs heavily if the trustee is saying, "Oh yeah, I agree with the debtor's own attorney that this all looks reasonable and fine." But if he's asking for these things and the debtor is dragging their feet and is not providing documents and is not responding to requests for information, then of course the trustee is going to get concerned. Not just that he can't evaluate properly what's going on, but that maybe there's something being hidden. And so often then we'll have to have a hearing and tell the debtor that they need to come in and testify and answer questions about all of that. And if they then either don't do that or aren't very convincing, then the judge may well say, well, if you want, you are asking to use a powerful tool of federal law here for your benefit, and if you're not willing to, provide basic information that we need to determine that you are a poor but honest debtor, then we're not going to allow you to use that tool.
Okay. No, that was what I had. Thank you. All right, Noah, if you want to go ahead. Yeah.
Yeah, thank you. Thank you, Evan. First of all, I think your cat has a question.
The cat is very unhappy to be on the other side of the door.
Yeah. So I wanted to ask about short sale. And I mean, I know there's an opportunity, there's an option for the seller to do also a short sale. So can you explain the differences between both, between short sale and bankruptcy? Because to me it has a lot of similarity. So
Okay.
about
Yeah.
about businesses, and when should I approach either one?
So, I mean, normal short selling, of course, is voluntary on the part of the mortgage company or other lien holder. It's something that you've negotiated with them and that they are willing to do for whatever reason. Perhaps they agree with you that the sale that you've arranged is probably the best that they're going to get, and that if they go up on the courthouse steps and try to hold a foreclosure sale, they're going to either end up with less money or they're just going to end up with the property in their hands and then have to go spend more money to arrange their own sale, and that's not the business that they're in. They don't want to do that. And so perhaps they are willing, they're willing to voluntarily say, yeah, sure, we will accept the money from the sale, and then we'll let that be the end of it. And in that circumstance, of course, there's debt forgiveness involved, because they are saying some amount of money that this person owes us, we are going to voluntarily forgive that in these circumstances. And so chances are they're going to submit a 1099-C to the IRS, and that person is going to have to pay tax on that income unless they are insolvent and can meet certain other rules. Whereas if they go into bankruptcy, whichever kind, and they say, yeah, we're just going to surrender this property. Go ahead, mortgage company, you can go ahead and you can hold your foreclosure sale. We're fine with that. But our personal responsibility for this debt is going to be discharged in the bankruptcy. There, the mortgage company does not have a choice. You are not reliant on them agreeing that is the best thing for them. The bankruptcy gives you the debtor the discharge, whether they like it or not, and they are left with their only recourse is to go after the property to try and get some of their money back. And once they have done that, that's the end of it. They can't come after you personally anymore. So there's that difference, and also there's the tax difference, because now there's no debt forgiveness, there is bankruptcy discharge. And unlike debt forgiveness, bankruptcy discharge does not generate a taxable income event.
Okay. So, I'm just curious. I mean, people can just file bankruptcy all the time, and all of their debts are going to be wiped out. I mean, I know it's silly,
Oh
but
yeah,
sounds
it,
weird.
it is a very, as I said, very powerful tool. Now there are limits on it. Some of the limits are things I mentioned earlier in terms of if you are somebody who makes $200,000 a year, chances are you probably can't file Chapter 7. And if you file Chapter 13, you are probably going to only be able to get a plan approved that pays back a substantial amount, if not all of what you owe people. Another aspect, though, is you can only, if you get a Chapter 7 bankruptcy, you are not discharged. You are not allowed to have another for 8 years. So there are time limits. The limits in between Chapter 13 are a lot shorter than 7 because 13 does involve payments. And so it's considered to be not less beneficial, but certainly not something that people would necessarily want to be repeating as often. So you can file a Chapter 13 bankruptcy and you can get through it, and then you can turn around almost immediately and file another one. Although most of the time there would be no reason for that because you're not supposed to be incurring new debt while you're in the middle of paying off your old debts in a Chapter 13, or at least not without court permission. But yeah, so looking at it purely from the Chapter 7, I'm able to wipe out all my debts and get a fresh start. You can do that every 8 years. If you do it often enough, the court might theoretically start looking at it a little bit more in depth. When you file like your third or fourth time, they might say, does this person appear to be abusing the bankruptcy system? The judge does have sort of the discretion to look at those things. But other than that, and of course, there's the limits on what you can protect. So it's also not like you can build up assets through this method, because as soon as you get beyond sort of the core of what bankruptcy wants everyone to be able to keep, now they're going to say, oh, well, you don't get to keep that anymore. That's going to go to peer creditors.
Got it. Thank you very much.
You're welcome.
Yeah, thanks, Evan, for doing all this. This is tremendous information. What about individuals who, say, have a government loan and maybe they've taken out something for business and, you know, things haven't gone well with the business. We know how many businesses fail. What happens with government loans? Is it still Chapter 13, or how do they generally work?
So there's a couple of different things there. One is that just as a blanket matter, debts to the government aren't necessarily treated any differently than debts to private corporations or individuals. There are specific exceptions to that. For example, if you owe like state sales tax, you were running a business and you were collecting but not submitting your sales tax, that doesn't get discharged. You can't get out of that. That was never your money to begin with, as far as the system is concerned. Income taxes owed to federal government or a state government or even a municipal government can be discharged, but only once they have gotten old enough and once certain rules have been followed. But you cannot go into bankruptcy and discharge tax that you owe the IRS from this year, last year, 2 years ago. Things like
what about like small business loans and things like that?
so SBA loans, for example, do not inherently get treated any differently. One way they can be a little different, though, is whether or not they are secured. For example, with the recent EIDL loans, if you took out I don't remember what the thresholds are, but if you borrowed less than, say, $50,000, then it was essentially an unsecured loan. And if you were to file bankruptcy, it's treated just like a very large signature loan or credit card debt. But if you had gone up to, say, $75,000, then I think the loans automatically said, we have a security interest in your accounts receivable and your equipment and so on and so forth. And there it's not so much that it's a government loan as it is that debts with collateral are treated differently in bankruptcy than debts without collateral.
Okay. Interesting.
Because debts without collateral, unless they have specific protection, and there is a very specific list of the debts that do have protection from a bankruptcy discharge, and it mainly consists of recent taxes, child support debts, debts that were incurred by fraud, student loans, famously. If you're not in that relatively short, if it's not in that relatively short list of debts, then it doesn't matter who it's to, it is subject to the discharge. Secured debts typically have two prongs, like a mortgage or a car loan, one of which is the personal liability and the other of which is the attachment to the collateral. The bankruptcy will discharge the personal liability, but it will not remove the attachment to the collateral. And so if the person doesn't pay the debt, they can still come take the collateral.
Okay. I actually wonder why a lot of these student loans, people who have huge debt don't just go bankrupt and get it wiped off, you know? Yeah. What are the safeguards in the system to prevent that, for example?
Well, that one's in specific is student loans are one of the short list of loan types that simply do not get discharged.
Okay.
Not just federal loans, but also certain private student loans. It started out in like the 1990s, where they just said, oh, you can get your student loans discharged, but only if you have been paying on them for at least 5 years. And then they changed it and said, no, 7 years, no, 10 years. And then in 2005, they basically said, yeah, you can never discharge them.
Yeah. All right. Very good. Thank you.
One more question, Evan. As far as things like solar liens are concerned, so the reason I bring that up is because I noticed, like, when I'm looking at an on-market deal, you know, if somebody has an arrears amount that makes the deal hard, the solar on top of it makes it impossible. And I know that in short sale situations that the solar can be discharged completely. From what I understand, does the same thing happen in bankruptcy? So if someone is in a tough bind, they file bankruptcy, can the solar be discharged and then now the property is available to sell without that debt, or how does that work?
So there are, not as a general rule, there are certain situations where it becomes very specific about what has and hasn't been done by the lender and what they're willing to do, because someone who is not a mortgage company, but is someone who has sold you a fixture like solar panels or some other improvement to the house, doesn't necessarily immediately have a lien on the property. They have extra steps that they have to take. Sometimes they don't take those steps. And if they don't and you file bankruptcy, then they're not allowed to go back and fix that. And so they can be caught out that way. As a practical matter, also, sometimes, as I mentioned, you have the personal liability and then you have the attachment to the collateral. And if somebody files a Chapter 7 bankruptcy and they get their personal liability for the solar panel debt discharged, and now the company is left with its only recourse being to come and pick up its solar panels, often as a practical matter, they just don't care anymore. It's not worth it to them. That may not help with a sales situation because they can still assert their interest in the sale. So yeah, it gets complicated there. Now you may also have been getting toward the idea of lien stripping, which is there is a circumstance that you can be in bankruptcy where you have multiple liens on the same property. You have a primary and a secondary, say, and the primary debt is greater than the value of the property, leaving the secondary lien essentially with no attachment to the collateral if you sort of line them up that way. You know, the house is worth $200,000, the mortgage is $210,000, and then there's this $50,000 second. In that situation, it is sometimes possible in Chapter 13 to strip the second lien. We can go in the Chapter 13 and we can say, okay, given that they're in this situation, effectively the collateral is entirely taken up by that primary loan. And so we're going to get to treat the secondary as though it was unsecured. And we can then treat it like we would a credit card or what have you. And then at the end of the Chapter 13, it's discharged and done with. And then afterwards, if they pay down the primary or the property increases in value, it doesn't matter because we've already got a court order saying this loan has been detached from this collateral and no longer has rights against it, and they're done. But that's not a situation where you can sort of use it as a tool for short-term stuff. It's like,
Right.
oh, I want to sell this house this year. You're not going to be able to get all the way through a 13 in that period of time and get
That's
that
what I'm
lien.
getting at. So there's no way for you to look at it and go, okay, here's a home with a lien, they have arrears, solar. If we can just get the bankruptcy in place, strip that solar lien, we can then sell it to the end buyer.
Yeah, generally, I think there are some states. This is not bankruptcy is supposed to be uniform across the United States. It's not. It is affected by local property law and such. There are some states where I believe you might be able to, but Texas is not one of them. Texas says Chapter 7 doesn't let you do lien stripping.
Okay. Yeah, I'm just mentioning that because I deal with a lot of these situations, and solar, if I could sort of get around the solar issue, it would make a bigger spread and make it easier to get the deal done than to have to, juggle trying to figure out solar issues.
I like to have a solution for them too, because they are also a pain for me in Chapter 13s where people are trying to save their house. And we have to decide what to do about these solar people here. We can't afford to pay them. And the homeowner is like, yeah, I'm willing to have them come take the solar panels if that's what it takes. But they're not interested. And so they just never do. And so we have to.
So that's a long journey, and it's a crapshoot. You have no idea whether it's going to happen or not. It's going to take more than a year, possibly.
Yeah.
Okay, so that's not a good solution. Okay, thank you.
Awesome. All right, I had one more bonus round. Okay, so I talked to a seller where the property was owned by his father. His father filed for Chapter 7 bankruptcy. In the midst of him filing it, the father passes away. So when that happens, does that bankruptcy automatically get canceled, or can the executor of the estate pick up where their father left off?
I mean, if it was specifically a Chapter 7, because that's the shorter kind where typically it's over and done with in 3 months. Then if the person passes away and I mean, if it's a married couple and one of them passes away, then there are ways that we can get the other one through to the end. But if it's the only person who was in the bankruptcy who passes away, generally speaking, at that point, unless they had already met all the requirements to complete the bankruptcy and we were just waiting for the final deadlines to pass to give them their discharge, in which case they might still get that and it might matter to their estate. Generally speaking, you can't keep it going with no debtors in the case. And it's going to get, I mean, I have had a couple chapter 13s where it was kind of like that, where mom or dad had their house in the bankruptcy and were paying on it, and they pass away and the kids say, well, what do we do? And I tell them, well, if you can keep the money flowing to the bankruptcy trustee, then as a practical matter, it will probably keep the bankruptcy going for a while. It's not going to be a permanent solution though, because when it gets, if there is any kind of event at all in the bankruptcy that requires the participation of the debtor, there's not going to be one to participate and it's going to fall apart. And specifically when it gets to the end of the chapter 13 and they start saying, oh, okay, well, let's do the final administrative paperwork to wrap this up, there's no one to do that. But as a practical matter, that could still, it would depend heavily on the circumstances. Like if it is one of these situations where they're trying to fix the mortgage and say they've gotten far enough into the bankruptcy that it's now only $1,000 behind, and if just 3 or 4 more payments get made in the bankruptcy, that will get paid. And then if the bankruptcy ends, it doesn't matter so much because now the mortgage is already current, and as long as the kids keep making ongoing payments, the mortgage company isn't going to care, which sometimes it won't. That can be good enough.
Okay. Yeah. So I don't know if you know a lot about like probate, but can an executor of an estate file bankruptcy?
No, executors and trustees of various kinds cannot file on behalf of a probate estate or a trust. Yeah.
So typically their best bet is sell it. If they can't sell it, then just let it foreclose.
There you're getting a little bit beyond. I don't know whether someone who was knowledgeable about probate would know if there are any other tools that are available to them. I don't want to say definitively there's no bankruptcy help to be had there. I don't know if there would be any other angle that could be attacked from in probate.
Okay. No, I just thought that was I only came across that once, but I thought it was interesting nonetheless. Okay.
Yeah.
So also in Texas, I believe it's a non-judicial state. So, for example, is that correct? Or I guess
you kind of shorthanded there. What are you meaning?
For Texas, it's a non-judicial state, meaning I think it's both. It depends. But if somebody files, let's say I go down, I'm in Texas, I file bankruptcy, but I don't have an attorney to represent me, right?
Okay.
How long do I have to either get an attorney to go through with the bankruptcy, or how long will it take until the lender dismisses that?
Oh, okay. It sounds like you're thinking of like non-judicial as being some broad application to all different kinds of law, and it isn't really. That's what confused me at first, was usually when somebody's talking about something being like judicial or non-judicial, they mean specifically an application. For instance, Texas does allow for both judicial and non-judicial foreclosures, where it is in the law that you can go up on the courthouse steps as long as you followed the proper rules, and you don't have to have any kind of court order to do that. But you can also go to a state court and say, I want to foreclose on this property, and I want an order from this court, to do that. Specifically in bankruptcy, lawyer versus not lawyer, what we call it when somebody files without a lawyer, technically speaking, is that they filed pro se. That is allowed as long as it's for an individual. And if they are lucky and work hard, they may be able to carry it through successfully without a lawyer, usually only if it's a Chapter 7, because with a Chapter 7, as long as they are able to Google or otherwise figure out all the forms they need to fill out and do a reasonable job of correctly filing all the paperwork, then they may be able to muddle through, as long as they're fortunate enough that their situation didn't have anything that a lawyer would have gone, oh, wait a second, you don't want to file a bankruptcy with that. Chapter 13s almost always fail if somebody doesn't have a lawyer to help them, just because there are so many complicated hurdles and they are near the beginning of the case. And usually it's not like the creditors who are going to make it fail. It is going to be the trustee saying, this person hasn't filed the things that they need to file, judge, and they need to either get a lawyer to help them, or they need to figure out how to do it themselves, or we need to terminate this bankruptcy because it's not going anywhere. And we're not going to be able to get a coherent plan that I can administer. And our local Chapter 13 trustee tries as best he can to be helpful to people in that situation. And he both tries to be very patient with them, and also tries to steer them to local attorneys, and say, you think you can't afford a lawyer to help you with this, but you would be surprised. Please go talk to someone.
Nice. Okay, got it. All right. Well, that was all I had. Anyone have any last minute questions for Evan? 3, 2, 1. Okay. All right, Evan, you're safe. That was it. All right. Again, really appreciate you coming out and doing this. So if people are in Temple, Killeen, Waco, in that triangle, do you practice anywhere outside of that, or that's the only places you like to focus?
I file bankruptcies for people throughout what's called the Waco division, which includes McLennan County, Bell County, Milam, Freestone, Limestone. I'm trying to think of them all right now. Basically it's pretty much all of the counties that are touching McLennan and Bell. And I also will occasionally file bankruptcies for people who are down toward Austin, who are technically not in my area. But if it's a relatively straightforward Chapter 7 case, I'll go ahead and help them if they have some reason why they want to go with me and not someone down closer to Austin.
Perfect. So if people want to send you referrals or refer people to you, how can they reach out to you?
They can either have somebody call me at 254-399-9977, or they can send them to my website at hotxlaw.com, which has all of my contact information. Those would be the best ways.
Okay, perfect. All right. Well, guys, if you are in, again, like you said, Bell County, McLennan County, obviously we work a lot in that triangle, Temple, Waco, Killeen. So, but if you guys are working in that area and you have a seller that might be looking to file bankruptcy, Evan is definitely there. So appreciate you so much. And I know I still had more questions, but I want to be respectful of your time. I think we do this again soon.
Yeah.
I'd love to have you back.
All right. right. Well, thank you.
Thank you so much.
And it was a pleasure speaking to you all.
Yeah.
Amazing. All right.
Thanks, Ally, for putting it on. Thanks, Evan, for all the great info.
All right. Well, you all have a good evening.
All right.
Appreciate it.
That's it, guys. We will be back at it again tomorrow. That's foreclosure night. So if you guys have more questions about foreclosures, that's going to be with Nahid and Josh. So we'll do that tomorrow. But other than that, guys, if I don't see you tomorrow, maybe I'll see you Thursday. Other than that, have a good night.
Bye, everyone.
Bye.
Bye, thank you.